Now, why is it important? Because Belarus and India are two different, similar but little too different. They have civil laws and we have different legal systems. They have civil law legal system, we have common law legal system. They go by the code, we go by the code as well as what has developed over the court judicial precedents. Then, contract structuring and regulatory compliance. Any contract that we are getting into, well, that applies equally to also within the same jurisdiction. I'm so sorry. Scope of work and technical specifications. Whatever business we are doing, we must clearly outline the scope of work, the technical specifications of what we are getting into, the product specification that we want, that must be very clearly outlined. Pricing mechanisms and currency denomination. Well, we all know how Belarus is currently volatile, as also explained by our guests. We need to have a very clearly laid down pricing mechanism and currency denomination in our contracts. As in fact rightly said by Mr. Anton, that we can have rupee engagements, rupee invoicing with Belarus transactions, and that can be easily facilitated by our banks, thanks to Central Bank of India, sir. And instead of going for USD or Euro denomination, because those are currently not guaranteeing the payments. Payment terms and security arrangements, again, similar issue. Delivery obligations and risk allocation using internationally recognized Incoterms. These must be very clearly outlined. Incoterms are indeed helpful, are indeed standardized, but it is always best to also lay down in the contract specifically. Incoterms can be understood as model terms, standard terms, but contract must specifically and clearly lay down your terms. Warranties and limitation of liability provisions. Warranties are what ensure that no party gets into, well, the one who is claiming warranty does not get into any kind of losses. Intellectual property ownership and confidentiality. This intellectual property issues becomes very relevant where the arrangement is of technology transfer, or in fact intellectual property in the goods that are being supplied, so that the local manufacturer doesn't start making goods under the brand of the other contracting party. Compliance obligations. Who would be responsible for what kind of compliances? We always have this where we explicitly note down in the contract that while the Indian contracting party will be complying fully and will be fully compliant with the laws of India, we equally impose obligations that the other contracting party from Belarus, or for that matter, any other party, is fully compliant of their respective jurisdiction. So this must be really and categorically spelled out in the contract. Force majeure and hardship clauses. Now, this is something that is the most crucial clause these days, considering the war situation that we have around the globe. But if in case these are very well drafted, the parties can seek protection from their obligations, can seek indemnity from their obligations. Termination rights and post-termination obligations. Well, there's always an end to a situation. So if in case any party wants to terminate the contract, it can either specify, both the parties can mutually specify for what is the time period for which the contract is being entered into, and when can the party, for example, upon a default by the other party, they can any day terminate the contract. Now, what are the regulatory compliance requirements? Customs laws, import-export regulations. Both the parties have their respective customs laws, import-export regulations. And I think one of our previous speakers discussed upon the issue that for Belarus, Eastern Eurasia Economic Union has a common customs regulations, whereby even if we supply the goods to any of those nations, Kazakhstan, Russia, then the goods can still reach to Belarus. So similarly, well, not similarly, but those goods can be brought into India subject to the compliance of customs laws of India. Product standard certifications and labeling requirements. In India, we have a strict law on the products standards, certifications, and labeling requirements. These need to be met out while these need to be understood and met out by the parties while supplying goods in India. Foreign exchange regulations, these again are the most important compliances depending upon which party is receiving the money, because the basic principle about foreign exchange regulations is to maintain the maintain the state's balance sheet at the end of the year. What is coming in should not be, should not be going out rightly. Competition and antitrust laws. Uh, while any major Indian or Belarusian entity, when they are investing into the other country, they must be very mindful of their competition and antitrust laws, so that they don't end up paying hefty penalties. These laws are intended to avoid monopolistic or oligopolistic market in any country. Data protection and cybersecurity requirements. These are up and coming requirements that are coming up because of the advancement of technology. Sector specific licensing and approvals. For any, India is India is quite regulated, not highly regulated, quite regulated in terms of what licenses are to be obtained. In fact, there are there are licenses for any activity that you are required to do. So for these, depending upon what business is a Belarusian entity coming into India, they would need to obtain the license. For this, we need to have the local consultant or lawyer that can guide on what licensing requirements, licensing and approvals would be required. Getting paid and staying compliant. Payment terms, as we all know, right, as discussed by Belarus bank counterparts also, we can do these in Indian currencies and avoid USD and Euro settlements. Incoterms and a distinction that bites. One, free on board, CIF terms, delivered at place, delivered duty paid, and these terms must be very specifically, categorically captured in your agreement. The laws. Two doctrines and the sanctions question. Belarus has civil code, India has contract act. Belarus goes strictly by their civil code and what is written, while Indian contract act does go by Indian contract act, but it has evolved over the years. And even today we have laws that are still evolving, like Companies Act, like insolvency laws, like goods and service taxes, like income tax. So we need to be very mindful of what law applies to what kind of transaction. A well-drafted clause should should be one that navigates you through the issues, through the situations, through the bad situations, and provide you the resolution in case any issue arises. Choice of applicable law. Both the countries provide for the situation that party autonomy is the supreme. Parties can choose what law do they want to settle for their agreement. If they want to have dispute resolution in India, they can choose that. If they want to have dispute resolution in Belarus, they can choose that. Yes, this principle does not really apply to the immovable properties. That is a very the law on that subject is very situation based, citus as we call it. Now, in case of dispute, litigation at all cost must be avoided. Litigation, by litigation I mean state approach, state organized litigation sorry, must be avoided. By state means the courts. Rather, the parties must look at resolving the disputes through arbitration. And for arbitration also, arbitration is essentially court, outside the court settlement, outside the court dispute resolution mechanism, whereby we have one arbitrator who listens to the parties and to the terms and then resolves the dispute. I will quickly wrap up. These are the certain essentials of an arbitration clause. Institutional rules, institutional arbitration we can resort. What will be the seat of arbitration? How many arbitrators will be there? What will be the language of the proceedings? And which law would apply to the arbitration dispute resolution? There are certain institutional forums. SIAC is currently one of the best. India itself is also coming up with Mumbai International Arbitration Center, Delhi International Arbitration Center. Banking and risk, I need not delve into this. Yes, apostolization. This is one thing where, while submitting documents in the other country, this is what comes very handy, the Hague Apostille Convention. Since both the countries are part of this convention, if the document has been apostille in India, that is very, very valid document in Belarus. Similarly, document that has been apostille in Hague is very much valid in India, in Belarus, I mean. Then coming to practical recommendations, investment protection and risk mitigation. These are the basic tools, comprehensive shareholder agreements. The shareholding agreements must be very comprehensive. We have political risk insurance, credit insurance, parent company guarantees, escrow arrangements, and letters of credit. So these are the mechanisms with which we can mitigate the risk. And these are certain recommendations how to evade any risk. We must conduct due diligence on counterparties and supply, verify sanctions, what sanctions are currently applicable. We need to modify the contract or prepare the contract in a manner that it is locally suitable to the local requirements. This is pretty much that I have within the limited time that I've been given. Thank you all. This is how we can help. GRATA International, just a brief about GRATA International. GRATA International is a network of law firms which is spread across 27 jurisdictions. And we, Legum Solis, being Indian lawyers, are part of that organization. This is where we can help the delegates, the Belarusian businessmen entering into India and the Indian businessmen that are looking to enter into Belarus, because one of our partners is from Belarus. Thank you all. Have a good day.